I would like to introduce my speakers tonight. And so tonight we have Matt Speiker as one of our speakers. He serves in outside general counsel capacity for business in all types and sizes. Matt supports in-house counsel, senior executive teams, sales personnel, and can be counted on to appropriately address legal issues that are extraordinary and those that arise part of the day-to-day business activities and operations. When necessary, he'll facilitate an introduction of subject matter to industry experts. And I can vouch for that because it's gotten to the point now, I know you don't do everything, but I just refer everything to you. And you know everybody, so it works out really well. But Minja assists clients through all stages of litigation process, from commencing the litigation and providing a defense, conducting discovery, participating in trial, and if needed, engaging in the process. She works closely with clients to develop early strategies to manage both business and litigation processes. Her practice focuses primarily on commercial litigation, both in state and federal court, includes cases involving business torts, contract disputes, negligence actions, construction, and real estate disputes. And she's a director and officer of defense and trust in estate litigation. How'd I do? Without any further ado, will you give a big round of applause for our speakers tonight?
I think it's working. Yep.
Okay. Hi, everybody. It's great to be here. Visited with a few of you before we got started, and it's really neat to be a part of a room of people that are really enthusiastic about something. In this case, it's real estate. Tonight, we're going to tell you a little bit about our firm. I don't want to bore you with the details, but I do want to give you a flavor for the depth of what we do. And then we're going to hone in on what do we do on the real estate side of things. I'm a paper pusher. She's in the courtroom. What do I do as a paper pushing real estate attorney? What does she do as a litigator? What does that look like? What are typical cases that we see? I know some of you have atypical approaches to real estate investing, which I've learned, and we see those too. And then after that, I think we'll turn it over and do some Q&A if people have particular questions or issues that they're interested in. Obviously, we're not intending to create an attorney-client relationship here today, so we want to talk about what we see in the market, locally, regionally, nationally, and obviously this is can be a group share. So if you have questions as we're going, don't be shy. Also, I have a pinched nerve in my neck, so if I start convulsing or something, don't worry about that. I'll get over it. So.
One thing too, we are recording this for a podcast, and it's live on Facebook. So we have a microphone there. So if you have questions, please either point at me for the microphone or just go to the microphone stand. But please, everybody, use a microphone for if you have anything to say on there, and then just keep it close to your mouth so everybody can hear you guys. Thank you.
So Koley Jessen was founded in 1988 as primarily an estate planning law firm. What happened over time is our high net worth estate planning clients had other business interests, and maybe they owned a company and they needed to fire an employee, so they needed an employment attorney. Or maybe they wanted to buy a company and they decided they needed to find an M&A attorney. So over the course of 30 plus years, as our clients grew and the nature of commerce changed, our firm has grown. Today we have over 100 attorneys, and I think it's easier to describe what we do with reference to what we don't do. We're not a criminal defense firm, and we're not a patent law firm. So if you get in trouble with the law or you have an invention, we can connect you with the people that can help you. But really we focus and think of ourselves as a business-oriented law firm. So just some of our recent accolades we've received. We've been the M&A Advisor Law Firm of the Year, for the last 5 years. And that's an award that we are up against the biggest law firms in the country, Manhattan law firms. Really, our corporate expertise lies in middle market mergers and acquisitions, and that's industry agnostic, from real estate to healthcare, technology, banking. We have just quite a wide range of experience there. Going back to our go ahead, Ted. Going back to our corporate services, again, if it's business related and it's not a patent prosecution, we'll litigate patents, but we don't prosecute them. We can do it. I spend a lot of my day-to-day doing banking and finance, and a lot of that work is real estate lending, TIF financing, PACE, junior lien, senior lien, seller carryback financing, everything under the sun, permanent financing, Freddie Mac, Fannie Mae, that kind of stuff. We have a commercial and technology team that all they do is commercial and technology agreements, software as a service, licensing agreements. We have a data privacy and security team. We do general business stuff, healthcare law. We might represent your doctor. Intellectual property, trademarks, trade secrets, copyrights. Mergers and acquisition, that really drives a lot of our revenue at our firm. And again, that's a nationwide practice. And just one interesting anecdote on how that developed. We primarily worked locally in the M&A market, and you would have a private equity firm from New York come in and acquire our local client, and we would get to work opposite those Manhattan attorneys. And at the end of the deal, there's a settlement statement like there is in a real estate deal, and they would see that Manhattan private equity firm would see their law firm's bill, and then they would see our bill, which was a quarter of what Manhattan charged, and we've demonstrated through the course of that transaction that we could perform at that high level. So through that practice, those private equity firms started hiring us to do their middle market work. So that's what we do. Venture capital and growth equity. As it relates to real estate, a lot of folks want to acquire real estate. They want to take a big swing, and they want to use other people's money, right? How do you do that in a way where you don't end up in jail? How do you do that in a way where you can establish a real estate fund, and not only are you making income from lease rental income and from increase in property valuation, but how do you properly get income for managing the property, for managing the asset, for securing tenants, for doing all of those things? There's a right way and a wrong way to do it. We've got a guy in our office that I think is sort of top of class in doing those types of things the right way. Real estate, we'll talk a little bit more about what we do in that arena as we move on the presentation. And then environmental. We had an environmental attorney once. He would say, it's not illegal to pollute as long as you pollute within limits. So we help people figure out what those limits are and not cross that line. And sometimes that happens, and we help them clean it up too. So I'll turn it over to Minja to talk about the litigation side of the fence.
All right. Can you guys hear me okay? So here's some of the services that our litigation group offers. So the litigators, we're the ones that are typically actually in the courtroom, and the way that you can think of us is once there is a dispute or somebody's not getting along anymore, that's when we step in. So we have a pretty large group that does bankruptcy and creditors' rights. I'm not in that area, but it touches on a lot of things. I sue somebody, and then in the middle of the litigation, they have to file for bankruptcy, and then I get one of our experts involved, and they help them through that. Commercial, that's just kind of everything. It's just we're a business firm, and so any kind of business dispute that comes up, that's there. So like if a partnership is now not getting along and there's a dissolution, that's, for instance, something there, or just a regular breach of contract. I provided services and you didn't pay for them. Construction is very, as you can imagine, as you would drive around town, there's a lot of construction going on, and with that comes some construction litigation, and we do commercial as well as residential. I just had an arbitration 2 weeks ago where we represented the general contractor, and they had a dispute with her subcontractor, and it was a large wastewater lagoon installation, so it was like a $16 million project. So it'll range from that to just a homeowner buying a house and having issues with the builder. Real estate, and again, we'll touch on those a little bit more as we go into our presentation. Employment, that's employment disputes if somebody says that they were discriminated against, or a lot of that is really also advising HR personnel on what they can and cannot do, and can you fire them without repercussions in that case or not. Family law, we really have one attorney that does family law. I don't want to touch it. Not a lot of us do, but there's one person that kind of started doing it, and then he's the go-to person with family law. And so we used to say we don't do patent law or criminal law or family law, but we kind of have to, we say it now, we have to do family law too. Intellectual property, as he mentioned, we don't do really patent competition, but we do intellectual property, like if there's trademark infringement and those types of things, kind of like they call the soft patents, so we still do that. Personal injury, wrongful death. Again, we're not a PI law firm. A lot of times the way that this comes up is, if just like if you went to a personal injury law firm, we can do the work, and so we'll negotiate and we'll kind of do it on a contingency matter also on the basis, depending on the case. And a lot of times, like one of the ones I did, it was a good client of the firm, and then his mom slipped and fell at a Village Inn, and actually she died eventually, but not as a result of that fall. But that actually tried that case to a jury, and by the time it had gone to the jury, the mom had passed away. Her husband, who was with her when she fell at the Village Inn, and our case theory was there was a buckle in the rug, so she didn't just slip, there was something wrong with the rug. But in the meantime, he had passed away also. And so the way we had to get our evidence in is her son came in just a few minutes after this happened. And I'm assuming you guys don't know much about the evidence rules and all of that, but there's an exception where you can't say what somebody said outside a courtroom. But if it's an excited utterance and somebody's still in an excited state of mind and they say it, that's an exception, and now you can talk about what that person said. So we had to establish that when the son came in a few minutes later, that his mom was still in a lot of pain, that she was still really upset, and she told him what happened, and he got to tell us all about it. And we actually won. And I think she was 82 when she fell. And yeah, it was not something I do very often, but we do those as well. And then trust and estates, that's actually probably my areas of expertise along of what Ted mentioned. Probably my biggest are construction, real estate, and then trust and estates litigation. And this is the typical scenario is, there's siblings and everybody under a prior will has, their share equally. And then the mom or the dad, they're getting older. Maybe they developed dementia. Somebody's closer to them, and all of a sudden you find out that mom changed her will and John now gets everything and the others were cut out. So there's allegations of undue influence and lack of capacity by that person. And that's another big area. And it's kind of a growing area because there's a lot of farmland in Nebraska. And there's a lot of times it's one brother stayed behind. He was the farmer, and then he's treated favorably. And so there's a lot of wealth transfer happening also with the baby boomers and, retiring and not being well. So that's a little bit about what we do in litigation.
Okay, another area that's sort of outside the corporate litigation arena is estate planning. And we've got more estate planners. If you drew a circle from Minneapolis to Denver, Chicago, Kansas City, a circle in there, we've got more estate planners than anybody in that circle. We've got multi-billionaire clients, former senators. And the idea is, if you don't have a will, the state has one for you, right? So if you don't plan for your own affairs, there's a set of statutes on the books that says where all your stuff goes. Estate planning is really about making sure that the person that's doing their estate plan, that their wishes are carried out and that their affairs are in order. The idea is none of us ever knows when our time comes. But our loved ones, when you go, do you want to leave your loved ones with a mess, this financial morass of where's the accounts and how do we get to this and how do we put them in the ground? Or do you want to have all that stuff tidied up so they can actually grieve you and mourn your loss in a way that doesn't have all that heap on top of it? When I was a young lawyer, I worked at an estate planning law firm, and I was 25 years old, and I thought, geez, this is so morbid, talking about where people's stuff go when they die, right? But then I realized it's actually kind of a beautiful thing if you get it planned out and you take that load off of people, and they know that they've had their affairs in order. Like I said, if you don't have an estate plan, the state has one for you. Hopefully you agree with it. The other thing we do is wealth transfer planning. So there's an estate tax. I think the exemption amount's $10 million. So the entrepreneurs in the room, as your estate gets north of $10 million, basically, and you die, everything in excess of that $10 million is taxed at about a 50% rate. Well, and if you're married, it might be 20 million. And that there's always tension in Congress about what that level is. I think it's set to go down in a few years. I don't pay attention to that anymore because I'm not in that world, and I don't have $10 million. But on the wealth transfer planning, a lot of that is about minimizing the estate tax. You hear the story about the farmer that had 12,000 acres, and he died, and mom and the kids had to sell the farm to pay the estate tax, right? It's about avoiding those things. It's about taking advantage of, for lack of a better word, certain loopholes that exist in the IRS tax code to avoid and minimize those taxes. You get to a certain level of wealth, you basically decide, do I want to pay taxes and have Uncle Sam determine how my money is spent? Or do I want to identify charities and charitable purposes and give my money through those where I have control of how those funds are used? Short of that, there's a lot of things we do where someone might have a $100 million estate, and we can sort of turn that into a $50 million estate for tax purposes. Again, someone in that example is saving $25 million in taxes. They like it. High net worth people oftentimes have a family office. So you've got a bunch of, again, real estate is one investment class. It's the way that I look at it. It's one thing that you can invest in. You can invest in the stock market. You can invest in small business. There's all kinds of stuff you can invest in. Well, high net worth individuals want to be diversified in sort of their investments. And if you have enough money, you might have a family office. You might hire a money manager. You might have, you might have an attorney. You might have a controller. So I'll have to call him later. The family office idea is that it's a family. So think of a high net worth individual in town whose name's on a building, right? That person probably has a group of people that are managing their investment portfolio. Commercial real estate, multifamily, industrial, all the stuff, publicly traded securities, venture capital investments. And the idea is they're delivering a return to the family, and you hit a certain level of net worth, and you spend just as much time trying to preserve what you have, right, as opposed to growing it. Ideally, you do both. And then the most boring of all the practice areas, tax. But nevertheless, very important. We've got people that are specialized in income tax planning, sales tax, tax incentives. We talked about some of the estate tax. So those are some of the non-corporate, non-litigation services. If you want to fire somebody or hire somebody, that's our employment group. If you want to import workers from overseas, that's our immigration group. If you want to have a 401k or a benefit plan. And what you see here as you look at this list is that the law practice, to the extent you're interested, is becoming more and more complicated and more specialized. So I think Minja and I are sort of have resisted that specialization. We do a lot of different things, but the way the world is going, you should have, if you're an attorney and you're doing something that's sophisticated, you should be an attorney that's doing that day in, day out. So here's some of our representative clients. Now, we can't ethically say that we represent somebody. Ted accused me of being his attorney. That's okay, because Ted said it, but I can't say that. But these are clients that have agreed that we can say that were their attorneys. You see bigger pockets there. A lot of companies, local companies that you may recognize, and some that are out of Manhattan as well. And then just one real quick point before we get into the real estate piece. Part of our firm culture that's really important is that we want our folks to be involved in the community. So there is a very strong civic sort of push that we get involved in various organizations and give our time through that way. So that's just a list there.
This is just a small portion too. Can you hear me? Yeah. I was gonna say, because I know that I'm on the teammates board, and so there's a lot of organizations that are not on there, but we feel like the Omaha community has been really tremendously great to us. So everybody in our firm is pretty much involved in some organization. So, and I think you're doing this next one.
Okay, so real estate services. Here's a list of stuff that we do, right? We help people buy and sell real estate, lease, diligence, entity formation. Entity formation is again, you want to be a fund manager. You want to take other people's money and put it in a pooled investment vehicle and earn fees and management fees and all that stuff. How do you do that without getting thrown in jail? Or is it, hey, me and my buddy are going to buy a duplex. How do we structure that deal? And then use and entitlement, right? I've got some greenfield space here. It's zoned residential, and I want to put in a C-store. How do we get the government to say, yeah, we want a C-store there? On the purchase and sale side, so I had to put in representing lenders because a lot of what I do is representing the lenders. I'm not representing the buyer and seller. I'm representing the bank, making sure that the bank can get its money back if the investment doesn't go well. On the buy side or the sell side, one big thing that we do is negotiate the definitive agreement. Now, I've been pursuing a residential purchase of a house here for 6 months, and I know that if I find a house that I like and I give them Matt Speiker's lawyer-prepared purchase agreement, the broker's going to be like, no, right? They're not even going to look at it, right? So the negotiation, the definitive agreement really is in the commercial space. Given the way the residential market is today, if things slow down, I can pull out my nasty form again, right? And it is nasty. But for right now, I got to use the Omaha Board of Realtors form because the seller's not even going to entertain my form. There are a lot of brokers that have their commercial real estate form, and they'll say, hey, Jim, we're going to save you some money. You know, we've got our forms, and we had our lawyer look at them. I can tell you every real estate deal is different, particularly on the commercial side, and every real estate deal is going to have its own tension points, its own issues. I would suggest to you that using a lawyer in this context can ultimately save you money. There's that old saying, an ounce of prevention's worth a pound of cure. I'm the ounce of prevention. She's the pound of cure. It's a lot more expensive when you get into litigation. But give an example on the buy side. Okay, we want to buy this building. I'm going to work with my client and say, well, what are the representations and warranties we want the seller to make? We want the seller to make representations and warranties about the condition of the building. We want them to make representations and warranties about the systems, about encroachments, about all the stuff that we can, right? And when I'm on the sell side, no, it's as is, where is. Buyer, you're going to have 30, 60 days of due diligence, but you're caveat emptor, buyer beware. I'll let you come through, do your testing and all that stuff, but I'm not ensuring the condition of this building, right? There's a tension that exists there. That takes place in the negotiation of the definitive agreement. You guys know this stuff. We have a financing contingency, inspection contingency, all that stuff. Those features apply both in the commercial and the residential context. And then the other big part of what we do in the purchase and sale context, survey and title, right? In my view, you can't have one without the other. On a commercial property, you can give me a title report, but if I see a bunch of ordinances and easements and I don't have a survey, it doesn't mean, I don't know if the building's built on top of a drainage easement or electrical easement that says thou shalt not build on top of me, right? So in a perfect deal, we're going to get the survey and the title both, right? Because that's the whole complete picture. I get what's filed against the real estate records, and I have a picture. I have a map that I can tie that to and make sure that everything's okay. Environmental, again, we've got the former head of the Nebraska Department of Environmental Quality on our staff. He's really good. There are protections if you get the phase one. You guys might be familiar with that. You get the phase one, you can get a bona fide purchaser status, which is essentially federal protection under CERCLA from prior contamination. The phase one basically demonstrates that you didn't cause it. And then tenants, SNDAs and estoppels will help clients diligence tenants. You've heard of an estoppel certificate. Again, in the commercial context, I'm buying a strip center. I'm buying it from the landlord. It's got it all leased up. I give the tenants the estoppel certificates, confirm for me that the landlord says this is your lease and you're paying $3,500 a month and your pro rata share of the center is 20%. Here's an estoppel certificate, tenant. Sign this thing and confirm for me that the landlord's being truthful. We use those in the loan context too. And then an SNDA is again in the loan context, the tenant saying if the property owner gets foreclosed, we will recognize the bank as the landlord. Well, if I'm the bank, I'm going to require that SNDA as a condition to making the loan. So that's purchase and sale. Leases, again, represent landlords and tenants, guarantors. We help with diligence. The diligence might be the same on the purchase and sale. Again, as a tenant, I'm worried about the condition of the building. On the landlord side, I'm really thinking about what happens if the tenant doesn't pay. Can I get a lien on their stuff? In Nebraska, you don't have a statutory lien on your tenant's stuff, right? And you don't in the residential context, but in the commercial context, can I get a lien on their stuff and sell it if I don't get paid? Who's got money on the tenant side? Can I get a personal guarantee? And a lot of times on the tenant side, every landlord wants a guarantee, right? Well, in the right deal, I can negotiate with the landlord's attorney on, well, what are the terms of that guarantee, right? Does the guarantee burn off? If the tenant's in compliance and they pay the rent for a year, can the guarantee sunset? How about if I have 4 partners in this tenant? Can I have them each be liable for 25% of the amount? There's different devices and techniques, and if there's leverage there, there's an opportunity to get a deal done, and I'm looking to limit my client's liability, whatever side of the deal they're on. And just real quick on this, because I'm getting tired of hearing myself talk. We spend a lot of time on entity formation and capitalization, right? You're going to acquire an asset with your special purpose entity. It's going to be a mixture of debt and equity, right? Equity, on that side, we're looking at how are your ownership rights expressed, who's the boss, how is governance going to be addressed in the documents, buy-sell issues, what if we're partners, I want out, I want to move to I want to sell all my stuff and move to California. Can I force you to buy me out? Can you force me to sell? Can I sell to a third party? What if I die? What if I become incapacitated? What if I get divorced? What if the business needs a new roof and we don't have the capital and we can't get financing, right? Having those conversations, working through those issues. So at the end of the day, you might be investing with your brother or your spouse or your best friend, but I think having those things sort of predefined saves a lot of heartache for those times when you don't agree. Because if you don't agree, you look at the agreement. If you want to do something else, that's fine too. And then securities laws compliance. On the debt side, again, it can be a mixture. We help with bank loans, again, minimizing, typically on the borrower side, trying to minimize personal exposure. Permanent financing for stabilized properties, generally multifamily housing stuff, and then seller carryback financing. You guys have heard the expression contract for deed, right? You might have bought something on a contract for deed. I typically tell clients in Nebraska, you're better off selling it to giving title to the contract for deed buyer, taking a promissory note and a deed of trust. Why? Because foreclosing a contract deed, if you do it lawfully in Nebraska, takes a year. I can foreclose a deed of trust in 90 days. So some real advantages. And again, people think contract for deed. Well, I would do a promissory note and a deed of trust. I'm going to turn it over to Minja for real estate disputes.
All right. So Matt talked to you guys about things to do to avoid getting yourself in a pickle. And then I'll tell you about some stuff that you might encounter, that stuff that I see on a daily basis, kind of the real estate disputes that I deal with. So we'll discuss a little bit non-disclosure and residential real estate transactions, suits for specific performance, then residential and commercial evictions, and then kind of a miscellaneous pile that I have. So the first one, So this is a non-disclosure in residential real estate transactions, and I heard that some of you guys own residential properties. So this is, I deal with this probably, I don't want to say on a weekly basis, but I have cases that are always going on in this realm, but I probably have a new case every week or two. And so the typical situation here is, as you know, when you're, selling real estate, you have to fill out the residential disclosure statement, and while it's not a warranty, it has to be filled out to the best of your knowledge and has to be based on your personal knowledge, and you get to check the yes, no, or don't know. Well, what happens is there's a Nebraska statute that says that you, in addition to any claims for breach of contract, fraud, misrepresentation, kind of the general causes of action that you might have as part of any transaction, business transaction, you also have a cause of action for non-disclosure under this statute, 76-2120. And that basically says that if a claim is brought by the buyer against the seller in which they can show that you wrongfully or incorrectly actually disclosed information on the seller disclosure statement, not only are you liable for the damages, but you're also on the hook for attorney's fees. And if you've been fortunate enough to not have to do any lawsuits, that's great, but anybody who's been in the legal system knows that in America, and especially in Nebraska, we follow the American rule, so everybody pays for their own fees. So it might have the best case, and the other side clearly is wrong, and you have a 98% success rate. You're still going to have to think about what is your net best result, because you're going to be on the hook for the attorney's fees. Well, this is kind of a hammer, because this is something that you really need to be careful about. Because if you don't disclose accurately, maybe the issue is, there's a broken pipe. There's a lot of times it'll be like a sewer issue, and it's $7,000 to $10,000 to fix it. But if it goes to litigation, you might not be only on the hook for the $10,000 for the repair, but you might be on the hook for $40,000 in attorney's fees. So it's a pretty big thing. You got to be watching out for it. And so the way that it works is I will get a demand letter. And then it's either by a buyer or I will send it on behalf of a buyer to a seller. And what I will say is, this is your residential disclosure statement. You said don't know. Well, here I'll give you an example. Somebody filled it out just a couple of weeks ago, said they don't know if there was any sewer issues. Well, as soon as the house closed, like the second day, they had forgotten to drop off the garage door openers. So the seller comes by and drops them off for the buyers, and they're like, oh, well, we were having some issues with the sewer. Did you guys ever have any issues with it backing up in the basement? She's like, oh, yeah, all the time. And I had to go do laundry at the neighbor's house, and I'm so glad I don't have to do it anymore. Well, they thought because they sold the house and it was as is and they just put don't know that they're off the hook. Well, that's not how it works. You can't click don't know if you actually know. So I sent them a letter, and of course they responded within a couple of hours, like, when can we come out to get a bid and to get it looked at? Because as soon as you talk to a lawyer, they'll tell you don't want to mess with this. So that's one thing. Again, it's personal knowledge. You can't guarantee, and if it's something you don't know, that's fine. But think about it. It becomes a factual question, like, well, did you know? Should you have known? What's the evidence? And you don't want to leave it up in the hands of a jury or judge to decide. So err on the side of disclosing that, and when you have that area where you're disclosing, and then explain it, and then if they do it. And I will tell you, conversely, I was on the other side where somebody sent a letter to my clients, and they were like, well, you didn't disclose this issue accurately, and then in fact you disclosed it here, you clicked yes, but then you're supposed to fill it out on the next page, and it was blank because you're supposed to explain it. And so I wrote them back, and I was like, well, either A, you didn't read it and didn't rely on it at all, because you would have seen that it was blank. So, or you read it, you saw it was blank, you said, I don't care. So clearly you can't show me that there's any reliance on this provision and my client's not paying you anything. And I didn't hear from them after the fact. But that's kind of the situation that arises, and that's, I try to avoid these as much for the client and try to negotiate a settlement early on. But those are some of the things that we can help you that it's not an unlikely situation, I will tell you, if you do residential real estate, where something like this might come up and you'll be dealing with it.
There's a lot of people in this room that are flippers.
Yeah.
And a lot of times they never live in the home. And they put "I don't know" all the way across the board.
And so the statute has an exception if you wouldn't know it. So it's like if it's a trustee sale, if flippers isn't necessarily one on there. And I will tell you, I had a client in Iowa, and they are flippers, and they got stuck in a lawsuit, and it took us 8 months to get them out of there. And it was the same thing. Iowa also has an attorney fee provision. So we ended up getting a mediation, and what we ended up paying them wasn't that much, but the client had, I don't know, spent probably $15,000 or so in attorney's fees dealing with something where he was like, it's not my fault. Like, I'm a flipper. I wasn't there. I didn't know about these issues. Well, once there's a lawsuit, now you have to explain that. So unfortunately, you have a much better chance, I will tell you, doing the I don't know if you're a flipper, but it's not a guarantee.
And one thing I would say is there's an economic analysis that's going to take place that we can help you with. So maybe the non-disclosed issue is only a couple $1,000s, and you're right, you're the seller, and you were right, and you disclosed it, or you didn't know, and you're, gosh darn it, I'm right. Well, okay, you might be right, but there's an economic analysis, right? How much do you want to pay to be right versus can you pay a lesser amount and move forward with life? And a lot of people have a problem based on principles paying on a case where they're right. And the more they get our monthly invoices, Minja's invoices,
the more they're like, okay, the principal, yeah.
So, but I think she does a great job of sort of giving you that economic analysis out of the gate. Yeah, it's a small dollar issue. Yeah, you disclosed it, or yeah, you didn't know, but it's going to be cheaper to buy your way out of this than to fight your way out of it.
Usually settlement is the best approach. In that case, we did settle, but not as for a while, because again, the client was like, this is a principal. I did nothing wrong. I don't care. I'll pay you. I'm not paying them. Well, he did that for a while, and eventually he's like, I have better things to do, Minja. So we got it resolved, but that happens.
Would there be something that flippers in this room could do to better protect themselves against these situations? Should there be like a separate sheet that they sign off on saying like that you would provide, that we could buy through you, and then put that into our contracts with our real estate agents?
I haven't, because I don't draft. that would be on somebody in our real estate group. I analyze I usually do things after the fact. I kind of come in when it's too late. But certainly, again, it kind of comes to Matt's point. It's about leverage and what can you get away with and what can't you. Obviously, the more that you disclose, and I would say, if you know there's an issue, even though you can pick don't know, just disclose it, because then it's really hard, because then it's on the buyer, because they would have or should have known. But unfortunately, there's no guarantee that if you disclose it, I mean, what I tell any client is like, you can always do the right thing, and I can help you like win a case, but I cannot help you from getting sued, because unfortunately, it's almost impossible, because somebody can have a really, for lack of a better word, a bad case or no case at all, but they can still sue you. But the more that you disclose, the easier it's going to be for you to get out of it, the harder it is for the other side, because they're spending money to sue you on a losing case. So it's a lot easier to get out. So I would over communicate in that case.
Well, and Ted, I could see a situation where you said you have an acknowledgement signed by the buyer where they acknowledge, I think I turned it on.
Is this rain?
Test. You have an acknowledgement signed by the buyer where the buyer acknowledge a one-pager where they acknowledge that the seller has never lived in the house. I think that would be helpful for you in resolving the case at an earlier stage. So I think that would be an example of a separate acknowledgement.
It avoids it being as much of a fact issue, because now you acknowledge it yourself, you admitted it. So it's not a he said, she said. Somebody's going to get hail on that car.
Yeah, you notice that Chad back there from Premier Claims is running off on the phone because he's getting the hail calls. This is part of the reason I think our attendance is so low tonight. It's because the storm was coming in. So thank you for everybody going through the storm.
Well, you don't want to leave at this point. Just take it out. All right, Ted out. Go next. So another one that we've seen is suits for specific performance. So as you know, because you're in the real estate industry, a real estate is unique. So the idea is that under the law, there's really no fair way to compensate you. And typically the way that we see this, and I've seen it before, is that you enter into a purchase agreement. As you know, that's binding and it's a valid enforceable agreement even before the closing. But now the seller wants to back out. I had that happen shortly. One instance was, for example, when right after the pandemic kind of started, my clients wanted to move out of, like, they were still moving to Nebraska, but like 4 or 5 hours away. That was their plan. And then COVID hit and their business locally kind of took a big hit. And they were like, oh, we don't know that we can get away. We don't want to sell anymore. And so I looked at them like, well, there's no contingency that I can see. There's really no valid reason. I was like, I mean, unless we can prolong it a little bit, but you're probably going to be on the hook and you're going to want to sell this unless you can negotiate something or you get lucky and they walk away and they find a different house. But of course, the market the real estate that has been, they love this house, the buyers, and what happened eventually is after a few months and talking to my clients, they changed their mind. Their company did better and they're like, we'll just sell it. But that's kind of the situation that comes up. I had one. It was almost like, it reminded me of like when I was in law school, because what had happened is my client was buying a home, but his daughter was going to be living in it, but she didn't have the cash to pay for it. So he paid for it cash. He executed the offer, said, you have to accept by 6 o'clock. If you don't, it's void. You can't accept it anymore. Well, he went out of the country. And so the question was whether the sellers had accepted it on time. There was a question of whether they signed it around 6 o'clock, but we don't know if they had signed it before or after. If they signed it before 6 o'clock, the offer was valid, they signed it. If they signed it after, that means his offer was revoked. They could no longer accept it because he said it's void after 6 o'clock. And then his daughter signed you can sign the acceptance page that you have received a fully executed copy of the contract. Well, his daughter signed it, but she wasn't the actual purchaser. And she can only be an agent and sign it if the authority was in writing, which she didn't have. So we actually had a bench trial on this, and the question came down to like the cuckoo's clock. Like, was it hitting 6 o'clock when they signed it? Like, literally, that was my fact pattern of like trying to decide whether this was an enforceable contract or not. So in that case, because he had put in a condition, you had to accept by 6 o'clock or it's void, kind of came back to bite him because the evidence showed that it probably was signed just shortly after 6 o'clock, and that the cuckoo's clock is what made the seller agent go like, hey, by the way, we should go sign it at 6 o'clock, because they weren't thinking about the legal ramifications at that point, and that you couldn't really accept it after 6. So that was kind of for me, that was a fun case because it really came down to like the legal mechanics of it. But unless there's a contingency included, you're kind of on the hook. The other one, what I have up there, is part performance. And this, again, in that case, my client was like, well, I already obtained financing. I was planning on moving into the house. That's not enough what we're talking about here. If you don't have a fully executed contract for whatever reason, such as that case where the acceptance was signed too late, if there's part performance that's so obvious and material, then you might still be able to kind of get away and still be able to enforce the contract. Now, again, you had financing, you really had your hopes and dreams, you had bought some nice new furniture for the house, that's not going to be enough. But did you maybe start, before closing, you went in there, you started getting it ready to install a pool, and you're halfway done, and that's a $100,000 investment? You're closer. But I wouldn't put my eggs in that basket, that part performance isn't something you want to count on. So try to paper it up. And then, so this is both residential and commercial. We do, evictions is the layman's term, but it's restitution of premises. So a lot of times it's the tenant isn't paying you. And what do you do then? So the rules are a little different from a residential versus a commercial context. Under the Landlord and Tenant Act, the rules are a little more stringent, as you can imagine, because it's not a commercial context, you're dealing with just individuals. It used to be that you send a 3-day notice to quit. You kind of give them a warning. You have 3 days to pay, you have to move out. That was changed a couple of years ago to 7 days. but that only applies in the residential context. In the commercial, it's still a 3-day notice to quit. And so I've had clients where they're like, well, they paid me, but I still really don't want them there. And unfortunately, if they pay you, you're going to have to wait for them to not pay you the next time. So they have 3 days. And then the way that it works is usually if you file a lawsuit, the other side has 30 days to respond. Then you engage in discovery. You talk about like the facts, you prove up your damages, and the litigation can, last 2 or more years. I've had one that lasted 6.5, so it can drag on. But the way that these statutes work is it's sort of like a bifurcated proceeding. So you have a restitution hearing, so that occurs 10 to 14 days after you actually filed a complaint, assuming you were able to serve them. That's the caveat. But it'll be within 10 to 14 days after you file a lawsuit. And all that the judge is going to determine is, are they late on rent, or it could be something else, some other breach of the lease. And if there's a finding that, yes, they're late, you get a writ of restitution. You could get a sheriff involved if they don't voluntarily leave. But then you still have a separate case for the damages portion. So if you still wanted to, if you think you can recover, you're not throwing good money after bad, right? If you think you can recover something from the tenant, then you can still pursue the breach of the lease or the guarantee. And again, in the commercial setting, it's similar, but it's again 10 to 14 days, and you can pursue it separately. And there's all kinds of rules what you do if there's stuff left behind, and depends on how valuable it is and what you can do with it. And so if you need to dispose of personal property, talk to a lawyer, because you can get in trouble there. But those are some things that, again, is probably something that, you'll encounter if you do this business long enough, that we can help with. I'm going to trial on a commercial eviction, and I shouldn't even call it an eviction. It was a good attempt at a business that unfortunately did not work out, and she had signed a personal guarantee. And because it was COVID, it took forever to find a new tenant, and it was $10,000 a month. So we're going to try to mediate it, but if we can't, there's a potential big $300,000 damage that I don't know that she has a good defense, because we did everything we were supposed to do, and we tried to re-let it. And she was like, I deposed her. She's like, well, I really wish I wouldn't have signed that guarantee, but I did. I'm like, yeah, I don't know what to tell you. It's unfortunate. So we'll see what we can do there.
Would there be any rights for like a short-term rental, maybe traveling nurses, Airbnb? What if they leave items behind, or what if they refuse to leave? Do you have to go through this process too, or is there rights that they have?
If it's an Airbnb, there's nothing statutorily provided. It's still, if you dispose on anybody's personal property, what I would say is it's called a Disposition of Personal Property Act, and it doesn't just apply to residential real estate or commercial. And so I haven't encountered it in an Airbnb situation, but my guess is I'm familiar enough with the act where I think it would probably apply in that situation. You would have to follow the same rules. And again, if you provide them notice and they pick it up, great. But if they don't, you might have to store it, and then they have to pay the storage fees. If it's less than $2,000, you can basically keep it. That's kind of what the act says. If it's, you provide notice, they don't do anything with it. If you reasonably believe, again, it's reasonable, right? If you reasonably believe it's valued at less than $2,000, you can dispose of it or keep it any way you want. If it's more than that, that's when you're going to have to sell it at an auction, keep the proceeds. And if, again, nobody claims it, you have to actually put it into the court system, and the state gets it.
So the only thing I usually get so far is beer left behind in the fridge, so I don't have to worry about that.
So you can keep that. I think you're safe. And so here's just some other things that we run into from just from a real estate perspective. Easement disputes. I actually do have one of those right now where two neighbors were getting along just swimmingly and everything was fine. And then one of the neighbors, so my client was a really avid runner, and so is everybody in her family. And so they had an acreage and they loved running, and it was this shaded area with these beautiful trees. Well, the other neighbor cut down all the trees when he moved his fence. And she was just mad because she had said, like, I'm okay with you moving the fence. I don't care. But, don't cut down the trees, because they were really mature, beautiful trees and provided shade when they run in this. And I think the guy, like, seems like he's, I don't want to say losing it, but he's having some issues where she's wondering about his mental health. But he cut down all the trees, and she was literally bawling when she saw it. And she was like, that's it. You cannot use my property anymore because he was using it as a shortcut to get to his farmland. She's like, you're done. You're not using it. So then he tried to file a lawsuit, tried to say that there's an easement by necessity, and then you have to show that it's been used for 10 years continuously and that it's kind of established, and it did not prevail on that. And then he didn't like his first lawyer. He got a second one involved, and the second one, I think, couldn't help him either. So eventually, he just didn't do anything, and then I moved to dismiss it, and it got dismissed. So they could technically refile, but they kind of lost that battle. So she was vindicated, but she was so mad about those trees. So again, boundary line water runoff disputes, HOA covenant disputes. These can get pretty interesting.
This job must be so fun. Get all these stories coming in.
Well, so one of them, I had go all the way to the Nebraska Supreme Court, where one of the tenants, she was living in a townhome regime, and it's, open. You're not allowed to have any fences. That's what the regime says. Well, she had dogs that she was keeping for her daughter that wasn't living there, but they were emotional support animals. And so she wanted to have an exception where she could erect a fence behind her house. What the HOA said is like, hey, you're more than welcome to have a dog, because there's others in the regime that have dogs. So you can have an emotional support animal, but you can't take it another step further and say it's now necessary for you to, violate the covenants and the bylaws and to, put a fence up. And she was adamant that she was able to do this. And we tried it. We won. She lost the fight. And she appealed it to the Supreme Court. And the Supreme Court found that it's not a necessity for her. And there were we said there's alternatives, reasonable accommodations. So we said you can have a privacy fence around your patio. You can have an invisible fence, which is not in violation, or you can just tether your dog just like other people do. And she's like, no, that's not going to work with my dog, special dog. What if somebody else attacks him? I'm like, well, that's just, that can happen anywhere. So anyways, so that was one. Another one was where somebody wanted chickens as emotional support animals. And I will tell you, he got to keep all of his chickens, because even though you're not supposed to have farm animals, if it's an emotional support animal and he went to the doctor, got a note that says it's his emotional support animal, and I was like, you guys, just let him have the chickens. It's not much you can do about it. Partition actions, we do those too. I have one right now. It's kind of sad because the mom and the dad had wanted to have their son on the deed once they pass away for the house to go to him, but they kind of, I don't know, the title company made a mistake. It wasn't me. I had nothing to do with it, but they put him on there as part owner. And so for a while he was paying rent to his parents, and then he discovered this mistake that his parents had him on there as a third owner. And so now he sued his parents to claim that he's been paying towards this house, and that they forcing a partition to sell it to him at a different. And of course his parents are just heartbroken. They're like, he's our son. We would have given it to him at a good price, but he got married in the meantime. They don't think the wife is being a good influence. So it's a really sad situation. But now the reality of that is, if you have a dispute about who owns the property and the owners can't agree, what's probably going to happen is, if we can't all get along, is the judge is going to say, well, we're going to have a partition action. We'll sell it, and you guys divvy up the proceeds, and we'll figure that out. So, and quiet title action. So that's similar. Instead of selling it, it's just determining who owns title to something. One interesting one that I had there was our client owned a lot of real estate and was renting it out for cabins or mobile homes. And one person, he passed away. He was divorced, and his daughter had predeceased him. He really didn't have any close family members. It turns out that while he was really good at paying his bills, he just like hated the government and did not want to pay any taxes. So he owned a whole bunch of like over $100,000 in taxes at his death, even though like he'd paid my client for that lot, like clockwork, like doesn't mind paying anybody else, but did not want to pay the government. So like he had some distant relatives that like, we don't want to open an estate because once we open it, he owns one house. It's just going to go to them because he owns so much in taxes. They're like, you keep it. We're like, we can't just keep it. Like, what are we going to do? We can't just like assume title to it. Like we don't have the title. Like we assumed this guy owned it because he brought it onto the site, but how do we know? So we had to go to court and did a quiet title action, had to publish notice to everybody. And a sister said, like, I don't want anything to do with it because, you know, it's going to go to the government anyway. I don't want to touch it. And so everybody kind of disclaimed it. And then we got an order saying that our client could keep the cabin, and he sold it and kept his cut from the rent that was owed. But kind of a weird situation because we went through a lot of hoops to like notice up everybody to get the judge comfortable with nobody wants this cabin. So, but yeah, so that's kind of an overview of what we do.
That's a good information there. So what kind of questions do we have? I got a whole slew of them, but I'm going to let you guys go first. If you got questions, I'll come to you. And then otherwise, we have the microphone up there you can go up to too.
Earlier when you were giving the example of, you know, with whole flippers fixing houses, can the liability always fall back on the contractors or just the seller as the investor?
Oh, for flipping? Well,
yeah,
that's a good question.
With the disclosure forms and stuff.
So it'll depend on, again, it depends on your knowledge. So what I will tell you, I had a situation come up where the seller, again, was like, I know the contractor that was on there. He reports to me every single day. We've had a situation where before we've run into an issue, he'll tell me, we fix it up. So I didn't know it in this case, so there's no way that he knew. So unfortunately, again, it'll come. Do you have a better defense because you didn't know about it? Yes. But if you're the one that's disclosing it, unfortunately, there's always some potential for a liability that flows through it. But again, the more that you can explain, you know, Joe was on this project. He used, you know, like it's a sewer issue. He used the toilet multiple times while they were there. They never had any issues. You know, it's really hard to kind of fight with that. And then eventually you might, you know, you'll be able to get it resolved. So the more that you can do, the better. But is it going to prevent somebody from suing you? Unfortunately not, because you're kind of the easy target in that situation, and not the contractor, because the contractor probably didn't owe them any duty. You had a duty to disclose accurately. The contractor did not.
I got a question for you.
Yeah.
So I was listening, I believe I was listening to Bigger Pockets podcast, and they had a situation where a gentleman had a property in New York, and I think he lived in California. It was an Airbnb, and somebody was shot and killed in the property, and he got sued. And I don't know what grounds he could be sued on, but as there's a lot of Airbnb owners in here, including myself, how do you protect yourself against something like that to happen? And what can you be sued for in that situation?
So that's actually kind of strange to be sued for, because usually there has to be some kind of negligence, or you're inviting somebody on there that you know you probably shouldn't have. So there's kind of liability is just like if you have somebody comes over to your house, and depending on what they're considered, whether it's somebody who's a trespasser or invitee, or somebody that's there but with limited permission, the law actually treats your liability differently depending on, you know, how much permission they had to be on there. So if somebody trespasses onto your property, you're not necessarily liable. But now if you have something that attracts them to your property, and then there's a potential for, like, you know, let's say you have a huge well, you have a huge hole on there on your property, and you're like, well, I didn't allow you on there, but you have no fence, there's no warning, and a kid walks on there and like falls into the well, you might still be kind of on the hook because there's something that maybe was an attraction, something that was a nuisance that you did nothing to prevent it. So it's like, what reasonable steps did you take? So in that case, if somebody was shot, Now let's say that you rented, somebody got shot and you rented somebody that like you knew had a criminal record or something. They have to somehow try to pin it that there's some basis where you should have reasonably known. But it's, again, takes me back to my original. It's really hard to prevent somebody from suing you. Are they going to have a good basis or a good claim? Sometimes no. I mean, I saw that Mariah Carey's being sued for, All I Want for Christmas Is You, that she plagiarized that, and she's being sued for $20 million like 30 years later. Like, does that person have a good lawsuit? I don't know. We'll see. Probably
There's a lot of bad lawyers out there that give lawyers a bad reputation. We have them in Omaha. They're all over the place. In that example, I think, what if it's a situation where your Airbnb, the lock was broken or the window didn't lock, right? And so, and maybe that person advertised the Airbnb as being in a super secure, safe environment, right? So I think Minja's point, there has to be some, what we would call negligence, some breach of a standard of reasonable care that would have to arise. But my guess would be that Airbnb owner either gave the impression that it was safer than it was, or there was some just substandard defect in the safetiness of the house that you would expect the front door to lock. You would expect the windows not to be able to open from the outside. So absent that, it's maybe just a scumbag attorney, which again, there's plenty out there.
It's interesting because I have a handful of Airbnbs, and I got really scared when I heard that story, and it was managed through a management company. Sure. And so I'm like, man, how are you liable for that?
Well, then again, you want to have insurance as well, right? Hopefully
an umbrella, and cover,
all that stuff.
What other questions we got? Yeah.
I recently had a tenant pass away. She was an elderly woman who lived with her daughter. So we're in the process of kind of moving her daughter out. And I was told that I have to disclose that someone has passed away in the property when I advertise it or when I'm talking to potential tenants. Is that true?
I've never heard of that. I don't think so.
Some states you have to disclose if someone was murdered at the property, but I'm not aware in Nebraska of a disclosure requirement for death.
The question is if you've been asked.
Well, so that's different because if you lie, now it's fraud or misrepresentation. So whether it's negligent or fraudulent misrepresentation. So I wouldn't lie about it, but I don't think you need to affirmatively disclose it. There's no such duty to actually disclose that.
A friend of mine who also has property, he just said, you don't want people to move in and then say, you didn't tell me, and then you got a problem.
Yeah. I mean, that's kind of up to you if you feel comfortable, like I'd rather just disclose it than them complaining about it after the fact. That's probably more, kind of your personal preference. But I don't think from a legal perspective that you have an affirmative duty to disclose something like that.
Can you guys use that microphone right there? Just I don't have a great signal in here, and I don't want it to crackle. It's right next to Marty right here.
Excuse me, if it was me. A fellow bought a $700,000 house on a gravel road, and now he's complaining he wants the county to hard surface that gravel road. In order to hard surface that gravel road, it has to be extended 1.5 miles north of his house. And he wants the landowners on that 1.5 miles to contribute $48 a running foot towards that hard surfacing. Of that 1.5 miles, I own about 3/4 mile. And I told him I did not wish to participate. and he sells ag equipment. I mean, this is aside from it, but he sells ag equipment. And I said, you know, the only way I could justify paying that kind of money is to develop that land, which I don't want to do. But it's hard for me to imagine a guy selling ag equipment wanting somebody to get rid of ag land, because where would you sell ag equipment if there wasn't ag land? But he's continuing to push this theory. He's got what, 500 foot of frontage, and I've got like 3/4 of a mile, and I just wondered what your opinion was on how successful he may be.
I don't think he has any legal basis for requiring that road to be paved. We've seen situations where there's a subdivision that's not in an SID, that's outside of the city limits. They want paved road. The county will say, and this is in Nebraska, you guys figure out how to pave the road and we'll maintain it once it's paved. But unless you're in some sort of regime, a subdivision agreement, or there's some agreement where people can, on a per capita basis, elect to pave roads, I don't see that he has any legal basis for paving that road or requiring you to pay for the paving of that road. I think you're safe.
Thank you very much.
Welcome.
I had a question about the personal property left behind and the $2,000 limit. Does that apply to all parts of real estate, residential, commercial? Storage specifically is kind of where my question lies on how that line is drawn before auction's required.
So it does apply to residential and commercial. There's some case law that specifically says that that act is not limited to the Landlord and Tenant Act. So because it applies to commercial, I would venture that there's a very good chance that it would apply to storage units as well, because that would be just another commercial property, just a unique type. But I don't know that I've seen any specific case law looking at it from a storage unit perspective. But if I was a betting person, I would bet that the act would still apply to a storage unit. Now, it's a little weird because if somebody is storing stuff in a storage unit and then just doesn't do anything with it, my understanding is that, so generally what you can do is you basically keep that stuff and then they have to pay the storage fees in order to ever get it out. And in the meantime, what you can do is if they, you publish notice, you try to give it, get the people to pay you. If they don't, you auction it off and then you keep the proceeds of what you're owed, just like you would with other property.
And there's no, who values the limit on where that go? Like, how do you have to document? Are you required pictures or?
Yeah.
I mean, I'm going to say it's worth less than they are if I'm the owner, right?
Yeah.
So,
so I'm trying to remember the exact language, but it says I think it's like reasonably believed. And so the reasonable believe is going to be looked at probably from a third person's perspective. So, if it looks like super expensive artwork that's original, probably nobody's going to believe that it's less than $2,000. If it's a couch that's 10 years old and you say it's less than $2,000, nobody's probably going to argue with you. Now, could it be some antique that's a lot more valuable, but you don't see the value and you think it's $100, but really it's, valuable more than that? Then I think you're still safe because there's a reasonable belief there. But that's a highly specific question. I would say, there's probably some risk if you just, if you're accused of keeping somebody's property that you reasonably should have known is over $2,000. But I think if it's close, you're probably okay. So long as you can show us 3 months.
What's the timeline on that then? Your 3 days is okay and you could immediately move after that? How long do you actually have to wait for that process?
For the property to be removed?
Mm-hmm.
So you have to actually provide them with notice, and you have to show that you actually try to serve them. And then if you're unable to serve them, that's when you have to do service by publication. So that would be like in a, one of the circulatory for 3 weeks. But I'm trying to remember. It's either 10 or 14 days that you have to give them after you've noticed. I think you have to give them so much time after they receive the notice to grab the stuff.
So
and
they
it's more than
sign
3
for their
days.
certified letter,
Yeah.
and then you need 2 weeks before you can actually
Correct.
remove the property.
Correct.
Okay, thank you.
Mm-hmm.
So to the Iowa gentleman, so I have a farm in over in Audubon, Iowa, and I own the last property at the end of the road. The only time it gets used is during harvest, and the county, basically the maintainers, they almost won't even come out there to maintain the road unless there's a school bus that comes down that road. So I don't know if that has anything to do with, in my belief, that we've had the same people on that road forever. And this guy, from what I got out of your story, he made a choice to buy that property at the end of that road. He knew what he was getting into. Again, I'm not a lawyer, but I don't see how he gets that. As to the property in properties, personal property, I was always led to believe that garage sale value, whatever it would reasonably bring at a garage sale. Obviously, if somebody knows, then, I mean, genuinely they're on notice. Are they going to tell the other person? Who knows? I just bought an estate knowing what was inside the garage: a car, truck, and a motorcycle. Guy's dead. Family doesn't want to open probate. Am I entitled to that property? My belief is yes. So I had my real estate attorney write it into the purchase agreement to get one of the family members to open probate. I said I would pay so much of the probate so that they could then get all their assets from his 401k and all that kind of stuff. So I got a good deal on a house and a car and a bike that I won't ride. And anyway, that was kind of that.
Good negotiating. I like it.
And that's the right way to do it, is to have them open their probate. So you did the right
Yeah.
thing.
So it's another niche. So the sister, there were 3 siblings that were left. The guy died. He never married, no children. District 66 house. It'll be on the market pretty soon. But my title guy's in the room. He's laughing right now because he said to me once, he says, "Mike, I have a lot of investors. Every once in a while they'll bring me a weird deal, but he says, you consistently bring me the weirdest stuff I've ever got." So, thanks, Al. They are weird, but persistence, that's all I can say. So,
That's awesome.
My question is in regards to cash for keys. A lot of investors here have used that potentially with the bad tenant, right? So I was thinking, I evicted a guy like a month ago. Weird situation too. And at some point, like 2-3 months ago, before that, I was thinking about just, cash for keys. That's like, I give you cash and you just take off, right? Let's not even go through the eviction process. But if you do that, is there kind of like a document that they should sign saying, yes, I agreed to this, and not like have a copy of the key and come back the next day?
Yeah, you want to sign a lease termination agreement, and you'd want, as a part of that, a release of all claims signed by that tenant. So an agreement that they're terminating the lease, number one, and then a release, I hereby release you, landlord, from any claims, cause of action, damages, whatsoever, howsoever arising. 2 paragraphs.
Yeah, ideally it would be, to his point, it's like you write it up, but if you even have something that's like in an email or text message where he's saying, I'm relinquishing possession, I agree to this, I will not hold you liable, like even something that's more layman's terms would still be better, but something in writing would be ideal in that case so they can come back and change their tune the next time.
Okay. And with that, I could have the sheriff come over call the guy for trespassing type of stuff. That would be doable.
Well, so if you're doing it just more where there's a dispute, like let's say he comes back and he says, well, I never gave up my right to be here, then you're going to have a harder time showing that he's trespassing. If you went through the formal process and you got a writ of restitution that says you now have immediate possession of the premises, then 100% you could get him for trespassing. And then probably if you put something in writing where he's saying, you know, in exchange for me only paying you $500, I relinquish possession and I'm not going to come back, and then he does, then you're going to have him for trespassing. But if you don't have anything in writing, that's probably going to be difficult for a police officer. Will say this seems like a civil issue. They might not do anything about it.
Okay, cool. That was it. Thank you.
Mm-hmm.
Okay, I got a question for you. Okay, so I think that you have a lot of people here that are trying to get partnerships going for the first time. And any advice that you'd have for creating a partnership between two investors that are going to start working together? How to structure anything that you'd recommend start preparing for before you come see you?
I mean, I think
Planning. That's
yeah.
math.
Well, I think it's generally you're going to be in a partnership or a limited liability company. That's the vehicle you're going to use, and then beyond that, it's really just talking about. We get a little bit nervous when we have two people in a partnership because it takes both people to agree to take affirmative, proactive action. When the two partners don't agree, then the status quo is what remains, right? So there are mechanisms to break deadlock and things like that. But I would think, and depending on the nature of the partnership, because I tell new clients sometimes, I'm like, they're starting a business or they have a venture. I say, look, we could spend all your money addressing legal issues, right? You saw the list you can see all the stuff that we do. Like, we can spend all your money doing that. Let's focus on the stuff that's important. And I think in sort of a venture, a real estate venture where you're just going to own a income producing asset like real estate, talking through the governance and stuff, and we're going to be co-managers and making sure that we avoid the securities laws. That's important. And then number two would be, what happens if you die? Am I going to be partners with your spouse? What happens if you want to sell to your buddy? Navigating through those issues, and I think a lot of times people get into a venture with somebody and they say, well, it's my brother, right? We're brothers. Nothing's ever going to happen. Those are the really nasty situations, right? And the idea is, let's go ahead and paper this deal so you and your brother, we all know that you've come to a meeting of the minds as to what the deal is. It's not that you don't trust each other. It's that let's be comprehensive and really eloquently lay out what the deal is so there's never a question. So again, the agreement is what we use when the partners don't agree on what to do. The agreement is the fallback, right? We have partnerships where the partners aren't ever going to look at the agreement because they're just clicking and they work well together. It's the agreement is that fallback when that clicking stops happening. We've predetermined, when we were getting along, how things were going to work out.
A great example is the son suing his parents over their own house, right?
Right. Yep, exactly.
Any other questions we have? Jim, you said you had a question? Okay. Anybody else? Well, you guys wrap it up then.
Yeah, I just say to wrap it up, and thanks everybody for having us out, Ted in particular. I don't want to speak for Minja, but for myself, I like talking through situations with people. And if you have a question, don't call me every day, right? But you want to call once in a while and say, I have this situation, what do you think? And we talk for 5-10 minutes. Again, I have to make sure that you're not teeing up a lawsuit against one of our other clients and those types of things. But if you want to talk for 5 or 10 minutes and you've got a situation, I'm not going to send you a bill. You call me every day, every week, I'm going to start sending you bills. But so I would encourage you, feel free to reach out. The way I look at it is, can I help you? Can you pay me? Then we can do business together. But sometimes I say, look, can I help you? And if it's something little, I'm looking to forge long-term relationships with people that are driven to be successful. So that's kind of my philosophy on law practice.
For an example on that, I've reached out to you probably about a dozen times in the last 6 years with interesting questions over the years.
Yeah. Probably owe you an invoice.
More in the last 6 months.
Call anytime.
Yeah, and I didn't prepare anything as eloquent as Matt, but just thank you guys so much for allowing us to speak here a little bit, and hopefully you found something worthwhile, and we were able to give you some tidbits of information that you can use going forward. And just like Matt said, you know, you can pretty easily find us. We're actually just down the street anyway, but you can always look us up and give us a call, and I'm more than happy to talk you through stuff. And again, I won't draft anything for you, but if you have an issue that comes up, feel free to give me a call. I'll be happy to help out.
Awesome. Big round of applause, guys. Come on. Thank you, guys. Thank you.